Assalamu alaikum, my dear learners. Today we are going to discuss module number 4 of IOSH Managing Safety. Previously, we have discussed module 1, module 2, and module 3. And this module 4 is related to understanding your responsibilities, mean as a safety manager, as a safety supervisor, what we have to do in the organization. And another question that when we are working as a safety officer, as a safety manager, what will be there to guide us? Mean what will be the source of information for the safety officer, for the safety manager, that what we have to do and what we have not to do. Ultimately, in this chapter, my dear learner, we have three main objectives. The first is, what does the law require you to do? Mean what the law is demanding from you, or what the law is expecting from you, that what you should do as a safety manager in the organization or as a safety officer. Then in the second learning point, we will discuss that how does the law work? Mean how law will guide you, and if someone will violate the laws, ultimately he has to face the consequences of the violation. This can be the personal violation as well as this can be the organization violation. It means that if somebody will violate the safety law, he will not be exempted. He will be answerable, he will be accountable, and in most of the cases, there will be the fine on violation of the law. In some cases, there would be the imprisonment. In some cases, my dear learner, there can be the imprisonment about 6 months. Imprisonment of safety managers, imprisonment of safety directors, or even in some cases, imprisonment of your employer if he is not managing the health and safety in your organization. Then the third learning point in this chapter, that is what are the key parts of health and safety management system. System is the combination of four components. System need people, equipment, environment, and material. So in this point, we will discuss that what is the system and what is the basically, in organization, there are different types of the system, like there is the financial management system, there is the human resource management system, and there will be the information management system, and as well as the health and safety management system. So we will also discuss in detail that what are the different parts of health and safety management system and how the health and safety can be managed in the organization efficiently and effectively. So we will discuss now one by one, what does the law require you to do. As a manager, yeah, you have a health and safety responsibilities, but what is there to guide you? Yes, when you are working as a safety manager, you would have a lot of responsibilities to fulfill in the organization. Your responsibilities would be related to the conducting the training, to carry out the risk assessment, to carry out the investigation, reporting, and record keeping. Me, as a safety manager, we have a lot of responsibilities, and ultimately, the goal is to ensure that the goal is to control the accident, to control the losses of the organization. But what is there to guide you? Again, you are working as a safety manager and you have been provided lot of responsibilities. You have been given lot of responsibilities. But question is that what will be there to guide you? What will be source of information for you? That what we have to do as a safety manager and what are your limitations as a safety manager? Ultimately, my dear learners, there will be the law. Law will set the boundaries within which the organization must operate. Yes, the law will set the boundaries that what we have to do and what not to do. And ultimately, in case of any failure, in case of any violation, ultimately, according to the law, that individual or that organization will be treated accordingly. So law will set the boundary, law will tell you that what we have to do and what not to do. The law attempts to be fair by requiring you to be responsible for reasonably foreseeable. Meaning, according to the law, that every employer is responsible to control the losses, to control the risk, which are reasonably foreseeable. Foreseeable means that which you can easily identify before happening. For example, during the visit, I came to know that there is a slippery surface. Ultimately, that is the foreseeable risk. If there is an unprotected edges, some workers are working at height, but there are unprotected edges. Ultimately, you can say that this will be the foreseeable risk. Foreseeable risk means which we can easily identify that this is the risk, and ultimately, if this risk will remain as it is, ultimately it will cause the accident in the features. So foreseeable risk is which we can assess, which we can identify, or at some extent you can say which we can predict that if it will remain same, ultimately there will be the problem. According to the law, employers are not responsible for issues they can successfully argue as not reasonably foreseeable. Yes, in most of the cases, your employer, your company owner will give the argument that I'm not a safety professional, I'm not safety expert, I don't know what is the risk and what are the hazards, but even I fulfilled my responsibility. I appointed the safety manager and has established the safety department, and I have given the roles and responsibility to the safety manager. So ultimately, I have given him the responsibilities, I have given him the authority as well. So he is responsible for good act or bad act. Ultimately, in case of accident, enforcement agencies will ask from the safety manager, will ask from the safety director that you are the safety expert and you are given the responsibilities with authority, with the resources. So why it happened? So my dear learner, in most of the cases, your employer can give the argument in front of the court that I am not expert. So, but minimum I fulfilled the responsibility. I appointed the safety manager. So there is accident. So who is responsible? Ultimately, that safety manager is responsible. My dear learner, there are three simple tests to determine whether a risk is reasonably foreseeable. How now the question is that how the person become the foreseeable, mean how we can identify the risk or hazard in our workplace. Ultimately, uh, it comes through the experience, it comes through the knowledge, and it comes through the expert knowledge. So basically, these are the three parameters. If we have these characteristics or quality, we can say that that safety manager or even we will be the foreseeable risk. Like the if we have the common knowledge, mean we have the theoretical knowledge and we have the industry knowledge. For example, my working experience is about the construction companies. Ultimately, this should be the construction industry knowledge and moreover the expert knowledge with multicultural and multinational and multi-industry experience you can utilize to foresee the accident or foresee the hazard of the organization. As a manager, you are required to assess reasonable foreseeable risk and reduce risk as far as reasonable practicable. Yes, according to the law, safety manager is responsible to carry out the assessment. Before the assessment, we know there will be the hazard identification that where are the hazards and what are the different categories of the hazard. Once the hazards are identified, then we will carry out the assessment. And again, we know assessment will be based on likelihood as well as the consequences. Likelihood is the chance of happening, and consequence the you can say that is the outcome of the happening. So, as a manager, we have to assess the situation. We have to assess the foreseeable risk. Then, accordingly, we have to take the control measures. Mean reasonably practicable mean we have to take suitable and sufficient control measures according to the resources, according to our capability. And we have discussed in the last lecture that as a safety manager, we have almost five types of control measures. First one is the eliminate. Mean we try to eliminate the problem 100%. If elimination is not possible, then we will switch over to the reducing, or you can say introducing some substitute as well. And then in some cases, the third control that is the isolate. And next one is the administrative control. And the last one is the personal protective equipment. So we have these five control measures which we can apply in the organization. The purpose to apply these control measures is to reduce the problem, is to eliminate the problem, even reduction that will be up to the acceptable level. In some cases, you cannot eliminate the problem 100%. There will be the residual risk. Again, you will see from the standard that either the residual risk is acceptable or it is unacceptable. So, as a manager, we have to carry out the assessment as well as the control measure. Now, the question is, how does the law work in the organization as well as the country? You know, when there is the accident in the organization, enforcement action will be taken against the organization, against the violators. Even the legal notice will be dispatched to the organization, and even victim's family will put the uh, case in the court against the civil law that my family member was working in the organization, and due to the negligence of the organization, he got the serious injury or he got the serious illness. So even court can give the order that organization will be closed and that will go under investigation. So again, that can be the problem for the organization. Ultimately, there will be a client loss, there will be the production delay, and moreover, there will be the low motivation level of the workers, and there will be the compensation claims and overtime costs and many other costs even organization has to face if there is an accident in that organization. So, my dear learner, usually safety law is considered as the criminal law. So, violator of health and safety law will be treated according to the criminal law. Even we have discussed that what when we are working as a safety manager and we are fulfilling the different responsibilities. Now the question is that what would be there to guide us? I told you there would be the different laws, different regulation. They will guide you that what you have to do as a safety manager and how you will control the losses of the organization and how you will control the damages of the organization. So here is the Health and Safety at Work Act 1974, which deals with the health and safety. It describes that what are the roles and responsibility of safety officer, safety manager, what are the responsibilities of the employer of the organization, and what are the responsibilities of the employees of the organization. We have discussed in the last session that there are some responsibilities of the employer. For example, employer is responsible to provide you the safe environment. Employer is responsible to provide you the safe equipment, allocation of safety budget, establishment of safety department, formulation of safety laws, as well as implementation on those safety laws, to carry out the risk assessment, to arrange the safety meetings and seminars. So these are the different responsibilities of the employer. But at the same time, my dear learner, there are some responsibilities of the employees as well, and employers are responsible for five things. Worker is responsible to take care of himself. Another worker is responsible to identify any unsafe condition. Worker is responsible to report any accident or any incident to the management. And worker is also responsible to actively participate in different meetings and seminars. And worker is responsible to ensure that all the working areas and all the machinery and everything is safe. If there's a problem, he is supposed to report. Then the second regulation, which will guide you that what we have to do as a safety manager, the management of health and safety at work regulation 1999. This is also the UK based law, which will tell you that how to manage the health and safety at the workplace. Again, there is the workplace health and safety regulation 1992, which deals with the health and safety. And there is the reader. Basically, this regulation is related to the reporting, that how you will report the accident. Either accident will be reported in verbal, in writing, or through email. What will be the way and what will be the time duration? If there is a fatality, there will be the different time for reporting. And there, if there is an injury or if there is an incident, then again there will be the different time categories or types of the reporting. So this reader stands for reporting of injuries, diseases, and dangerous accidents regulation 1995. These statutes are put in place by Parliament in an attempt to stop accident and before injury before they happen. Yes, basically, each and every country have their own regulation formulation procedure. Like in Pakistan, what we have to normally draft is prepared, and that draft is produced in the parliament for discussion, for improvement, and for draft approval. Because the parliament will approve that bill, that will be dispatched to the upper house, that is called the Senate. And once the Senate will approve the bill, again, that bill will be sent to the President of Pakistan, and final approval and final signature of the bill on uh, by the president. That will be the part of your regulation. That will be the part of the act. So the basic purpose of this regulation is to again to identify the weak areas and to control the accident before they happen. So you can say this is the proactive approach, that regulations are developed in peacetime, just that they should not happen. They just give the responsibility to the employer that what you have to do and how you will manage the health and safety in the organization. In criminal law, the state must prove its case beyond reasonable doubt. Yes, when there is a criminal law, this would be the responsibilities of the state or responsibilities of the government, or you can say attorney general of the government. He would be uh, justifying this case in the court that either this accident is the failure of the management, is the failure of the employer. Even that was the duty of care of the employer, but he failed to fulfill the duty of care or not. And again, he has to justify that there is the contributory negligence of the individual, even it is the total failure of the management system of the organization. Likely outcomes of criminal cases: when the criminal cases will be proceeded further for hearing, then the outcome can be in the form of possible imprisonment, that would be about 6 months, and there can be the fines and penalties and remedial order. Remedial order means organization will be given the improvement notice that we are giving you the time about 3 months that improve your practice, establish your safety department, allocate the responsibilities, allocate the resources. Otherwise, after 3 months, if your practice will not be improved, we are going to seize your organization. And in some time, organization will give the prohibition notice, prohibition order that your organization is seized for 6 months or for 1 year due to the repeated violation. Even we have discussed that when there is an accident, your victim family will put the case in the court, and there will be the hearing by the judge. And there are two types of the law. One is the civil law, and the second one is the, as we have discussed, that is the criminal law. People injured by the negligence of others or breach of statutory duty can seek compensation for. Yes, when someone is working in the organization, that employer is responsible to provide the safe equipment, safe environment. If that person is injured during the working hours or within the organization, ultimately, according to the law, that employer would be responsible to compensate the victim family. According to the civil law, the victim family will put the case in the court, and after the completion of the hearings, that court can give the order that to compensate the victim families. So that would be the compensation for the victim. To be successful, the claimant must show that, yes, when there will be the hearing in the court, ultimately the claimant means who's putting the case in the court, he has to prove the case that the defendant owed the duty of claimant of duty of, yes, he has to justify that the accident which happened in the organization, that was the duty of the employer, mean that was the duty of care of the employer, but he failed to fulfill his responsibilities, or the duty of care was breached, and ultimately that claimant will confirm that the accident which happened, that was the breach of basically duty of care of the employer. And the third one is that the injury was caused by the breach of duty of the care. Yes, the injury, the accident which happened, that is due to the violation, or that is due to the breach of this duty. So basically, claimant have to justify these three areas, that it is the duty of care of the employer, and in this accident, that duty of care has been breached, and this injury, this accident, this fatality has been caused by this duty of care. Then ultimately, court will proceed further. If the employer played a part in the injury, the claim may be reduced due to contributory negligence. Yes, there will be the hearing in the court, and employer can also justify that there is the negligence of the individual. Procedures were provided to the workers, personal protective equipment was provided to the workers, but that worker did not follow these procedures. So this is not the only sole responsibility or sole violation behalf of the management. There is the contributory negligence of the individual. And this, if this contributory negligence is proved by the court, that ultimately then there will not be the 100% compensation for the victims. There can be the smaller part of the compensation which will be paid by the organization, because that is also the contributory factor behalf of the employees. However, if other employees cause the injury, the employer may still be ultimately responsible due to vicarious liability. Yes, this is another issue, that if workers is injured due to another employee's fault, ultimately This was the responsibility of the employer to provide the trainings, to provide the awareness among the workers that workers are responsible for their own safety, as well as workers are responsible to protect other people from the harm, from the losses, or from the damages. In civil law, the claimant must prove its case on the balance of probability. Again, in civil law, there will be the hearing from employee side as well as from the employer side. If it is confirmed that the accident which happened, that is the breach of duty of care of the employer, then 100% compensation will be paid by the employer. And if there is a contributory negligence behalf of the individual, then there will be a less compensation paid by the that company. A decision made by the judge is a precedent, which means that the verdict of this case will apply to similar future cases. My dear learners, you might have the information that when we talk about the UK law, they don't have the law in writing. Basically, their judgments, their previous judgments become the part of the law, and those judgments are called the precedent law. I mean, for example, there was the case in 1998 that was related to the duty of care of the employer, and same case has been filed in 2024. Again, 1998 case will be based on this. Mean they will try to get the guidance from old proceedings, from old judgment, that what was the decision on that time. So again, same type of decision will be put in this case. So my dear learners, this is about this session, and we will continue this session, this module number 4 in next session. So this is all about today, and I hope you will get the maximum information related to the laws, related to the consequences, civil laws, and compensation laws. This is the time to say you Allah Hafiz and see you again.